Can I move my metal cart to the... I need some drawings. I might have to work on those after this.
So one of the issues is going to be that KOAT footage. Officer Cook is the one that was escorting someone when that happened.
Yeah, he told me you guys just subpoenaed him.
We did.
Okay.
I don't.
There could be privileged communication between you and your client. There could be privileged, I mean, what I consider work product between West and Omar.
And if they can do all right.
Yeah, so we can just have a chat. Please be seated. Members of the media, come on up if you would for just a second. I guess there's a couple of concerns. All right, let's get on record here in this case. This is CR 2014-1975 and CR 2015-14-16, State versus Stephen Casaus. Counsel, can I have your appearances this morning? Good morning, Your Honor. Nicholas Marshall and Wesley Jensen for the state.
Good morning, Your Honor. Cindy Leos and Tom Clark on behalf of Steve Casaus, who appears in court today.
Good morning. So I think we're ready to get started. There were some preliminary issues that we needed to address before we brought the jury up. I believe there are. Yeah, come on up to the podium. Yeah, come on up to the podium. No, not here. To the podium.
Oh, I got you.
Can you come up to the podium?
Oh, sorry,
You have something
Mr.
to-
Clark is going to argue this.
Okay.
Good morning, Your Honor. So the objection we received last night, redacted copy or redacted proposed redacted exhibit regarding Mr. Casaus' statement. And the state proposes to play Mr. Casaus' statement, I believe, in its entirety, except for certain portions that they want out. And our argument is, this is being offered by the state as a piece of evidence against Mr. Casaus,
Sure.
and if they're offering said piece of evidence against Mr. Casaus, consistent with rulings you've made in the past, they don't get to pick and choose the good and the bad. Specifically, there are three sections regarding statements that Steve has made regarding loving his children and being a good father. Now, you've already ruled about some parameters that doors that we can't open, and we're prepared to live with that. But this is not our exhibit. This is the state's offering a piece of evidence they believe implicates our client in serious crimes, and the rule of completeness would require that it comes in. It doesn't open any doors. The state can't open their own door to bring in other things later. At the same time, this is not a piece of evidence that we're offering on our case in chief, nor is it something that we propose to admit portions of. This is Steve's statement to the police, and it's our position that that based on your previous rulings, the state should either play the whole thing or not at all. And then, of course, if we're offering it in our case in chief, I think we would be required to live by your ruling about opening doors. But I don't think the state gets to use your ruling about opening doors, or us opening doors, to prohibit the jury from seeing things that Steve said during the course of his interview by the police.
Let me hear what the intent of the state is in terms of.
And Your Honor, there's two different things. There are two different discs that we're talking about from the edits. One is the lapel camera from one of the officers when they were arriving at the house, and that contains different information that was discussed between the officers, just communications between the officers. So it's not communications that were with the defendant or the co-defendant. That part we edited just certain portions of the lapel camera that dealt with the officer's initial interactions with the deceased and with the defendant. We think those are admissible, and we would be offering those up for admission by the court. I think what we have here is, though, and then the other disc is portions of the defendant's interview, formal interview at the police station, and we have cut certain portions out.
What portions?
Certain portions that we think that aren't relevant to the case. And what I think defense is trying to do is mischaracterize what the state is doing, because currently there's nothing in evidence. So what the defense is truly asking you to do is make the state admit evidence that they would like to have. They're trying to backdoor some character evidence and some other evidence that the state thinks is not relevant into admission without having to do it themselves. And it's in the rule of completeness isn't that you get to play the whole video. You only get to play the other relevant portions that are related to that segment of the conversation. And so that they're using the rule of completeness to try to include character evidence that has been excluded in our motions and from the motions in limine, and force the state to include it, and then not use the impeachment evidence that we could be able to use. It's the state's, from the state's perspective, we are offering the parts that we think are relevant. If you allow the parts the defense thinks are relevant, it is by defense motion, and that means the state could still then impeach those statements or offer the counter character evidence to the portions that the defense is asking.
Well, come forward.
Oh, okay, yes, sir. Thank you. Please be seated.
All right, good morning, ladies and gentlemen. Hope you're rested well. I have a few instructions for you as we get started this morning, and then we'll move right into opening statement of this case. So, again, the instructions I'm going to provide for you right now are just sort of preliminary in nature. They may change to some degree throughout the course of this trial over the next couple of weeks, but for the most part, they'll stay the same. It's important for you as we get ready to start this trial that you pay close attention to the evidence that's going to be presented in this case. And after you've heard all the evidence, I'm going to read the final instructions of law to you, which you must follow, and copies of those instructions will be provided for you when you go in to start your deliberations, and then you'll decide the case. So, as we talked about yesterday, you certainly are allowed to take notes. I'm hoping that everybody has a notepad and a utensil. You're certainly allowed to take notes, but you're not required to do so, folks. It's going to be important as we go through this trial, again, that you pay close attention. Listening and watching the witnesses as they testify here during the course of the trial will help you assess their credibility. And so the manner in which they testify, their memory, any behavior, their appearance while they're testifying, all that's going to help you decide their credibility as witnesses in this case. During the course of the trial, again, I think I said this yesterday, but if I did not, I'll repeat it, that the notepads will only be here and in the jury room. We won't take them outside of this. At the end of the trial, the notepads will be destroyed, so none of that will be disclosed. So just feel free to take as many notes as you want to, or none at all, if you so decide. All right? So now as the criminal trial begins, it usually begins with the lawyers telling you what they expect the evidence to show. Now these statements and other statements made by the lawyers during the course of the trial can be of considerable assistance to you in understanding the evidence as it's presented. But the statements of the lawyers themselves is not the evidence in this case. The evidence is going to be the testimony of the witnesses, any exhibits or facts agreed to by the parties, and after you've heard all the evidence, I'll then, as I said, provide the final instructions of law that you're to follow. The lawyers will then argue the case, and then you'll retire to arrive at a verdict in this matter. Now, it's my duty to decide what evidence you may consider. Your job is to find and determine the facts in this case, which you must do solely upon the evidence received here in court. Now, it's the duty of the lawyers to object to questions or testimony or exhibits that they believe may not be proper, and you must not hold such objections against the objecting party. That's part of their job. I will sustain objections if the question or evidence sought is improper for your consideration. And if I sustain an objection to any evidence, you must not consider that evidence, nor may you consider any evidence that I've instructed you that you must disregard. Now, by itself, a question is not evidence. You must not speculate about an answer to a question that I've ruled cannot be answered. Now, it is for you folks to decide whether the witnesses in this case know what they are talking about and whether they're being truthful to you. You may give the testimony of any witness, whatever weight you believe that it may merit. You may take into account, among other things, the witness's ability and opportunity to observe, their memory, their manner, or any bias or prejudice that the witness may have, and the reasonableness of their testimony, considered in light of all of the evidence in this case. Now, no ruling or gesture or comment that I might make during the course of the trial should influence your decision in this case. At times, I may even ask questions. I try not to do so, but if I do, such questions really do not in any way indicate my opinion about the facts or indicate the weight I feel you should give the testimony of any witness. Now, as was discussed yesterday in voir dire, there are certain rules that the lawyers certainly need to adhere to, and they will. If they don't have any contact with you when you get in the elevator and those kinds of things, it's because the court's instructed them not to have any contact with you. It's just so there's no appearance of any impropriety. So it's not disrespect in any way. They're just complying with this court's order, so understand all of that. We also talked about the idea that you keep yourself insulated in this case while you're jurors in this matter, so that when you go home, that you don't watch TV or read the newspaper if it's reporting about this case, so that you can decide this case based upon the evidence that's going to be presented in this matter. So I'll keep reminding you of that throughout the next couple of weeks. You'll get tired of me saying that, I'm sure. Now, I talked a little bit yesterday about the bench conferences. I won't go into that again. Just understand that that is a part of what happens. Again, there'll be the white noise. Sometimes we'll have the lawyers come up in front of the bench, and we'll have some discussions mostly of a legal nature that's really not germane to your role in this case. All right, with all of that, we're going to start with opening statement. Who would provide the opening statement for the state?
I will, Your Honor.
Mr. Jensen. Are you going to need the electronics during your opening statement? No.
Your Honor, Counsel, ladies and gentlemen of the jury, I'd like to take a brief moment to thank you in advance for your service. I know that you have many other things you'd like to be doing for the next few days, but you are an integral part of the system, and without you it could not function, and I want to express my appreciation. On December 27th, 2013, at 4:31 in the afternoon, Officer James Edison of the Albuquerque Police Department was on his way to a call when he heard a dispatch to 4909 Comanche Road Northeast. The dispatch indicated a small boy had fallen off a toy horse, hit his head, and was unresponsive. Since he was close, the officer asked the dispatcher to divert his own call, and he proceeded full lights and siren to the Comanche Road address. Officer Edison arrived 3 minutes later. He went to the front door and announced himself. No one answered, and he tried to get in. The door was locked. He went around the side, but saw barking dogs in the backyard. He went back to the front, and Stephen Casaus opened the door and let him in, stating they were in the back. Officer Catherine Wright came in right behind Officer Edison. Mr. Casaus pointed to the left and told the officers to go in that direction. He himself did not follow, but went in the other direction. The officers passed through a kitchen and into a large bedroom in the back. There, Officer Edison found Cynthia Varela Casaus, the wife of Stephen, standing next to a boy, later identified as Omaree Varela, who was lying on the bed. Officer Edison felt for a pulse, thought he found one, but couldn't find it again. EMTs arrived and quickly took over, lifting the boy off the bed and laying him on the floor where they tried to revive him. Stephen Casaus reappeared and entered the room while wiping his hands on a towel. Mr. Casaus took two younger children, Nevia and Estevan, or Little Stevie, to a room to keep them out of the way of the people trying to treat the other boy, their big brother, Omaree. Officers Edison and Wright talked with him there in that room. They asked him what had happened earlier. He said that he was at the house of a friend named Ed who was going to fix his car when he received a call from Cynthia telling him to hurry home, that Omaree had fallen and was not responsive. Mr. Casaus said he came home, tried to do CPR on Omaree, and put him on Cynthia's oxygen tank. He stated that Omaree was making gurgling noises, seemed to respond, and then went limp again. Mr. Casaus said he had been at home at least 30 minutes before 911 was called. Officer Wright asked Mr. Casaus to look at his cell phone to determine what time Cynthia had called him. Mr. Casaus did so, but he said he couldn't find it. Officer Wright called the on-call detective for the Crimes Against Children unit of the Albuquerque Police Department, Detective Michelle English. Detective English then contacted the other detectives in that unit, began assigning them tasks, and notified other units requesting assistance. Detective English herself proceeded to UNMH, where Omaree had been transported by Albuquerque ambulance. Omaree arrived at UNMH at 5:18 p.m. Paramedics had been working on reviving him ever since they took over from Officer Edison 45 minutes earlier. Dr. Brian Upham led the ER team that tried to save Omaree. Dr. Upham found no signs of life. Omaree's temperature was low, 84 degrees Fahrenheit. He was not breathing, had no pulse, and his pupils were fixed and dilated. Lab work was done on him. The volume percentage of red blood cells in the blood and hemoglobin was low, indicating bleeding somewhere. 4 rounds of epinephrine were administered to no avail. 14 minutes after arrival, at 5:32 p.m., Omaree was officially pronounced dead after an hour of trying to resuscitate him. Nurse Kim Brown was the lead nurse during Omaree's treatment at UNMH. After the boy was pronounced dead, she checked his body for signs of injury and found the following: a laceration on the left side of his head in the scalp above the ear.
Objection.
Nurse Brown found the following injuries: a laceration on the left side of Omaree's head and the scalp above the ear, a laceration on the left eyebrow, bruising on both shins, on his left wrist, and what appeared to be bruising on his groin, abrasions on his back and between his upper lip and nose, scars on his neck and on his head, and what appeared to be a bite mark on his right wrist, as well as what appeared to be 3 circular burns on his chest. Nurse Brown assisted a field investigator from the Albuquerque Police Department in taking pictures of these injuries. Dan Wasco, an investigator from the Office of the Medical Investigator, also took pictures of Omaree at the hospital. Mr. Wasco's photos show bruising on the lower back and on the upper left chest. Detective English and Detective Andrew Quillman of the Crimes Against Children Unit of APD interviewed Cynthia Varela Casaus and Stephen Casaus. Mr. Casaus was interviewed in the early morning on Saturday, December 28th, 2013. He was read his Miranda rights and waived them. When the detectives first asked him about the events of the previous day, he stated that he woke up at 12 noon or 12:30 p.m. He said he then went in the bathroom and washed his face. Then he called his mechanic friend Ed about fixing his Cadillac. When asked Ed's last name, Mr. Casaus said he couldn't remember. Mr. Casaus said he drove over to Ed's place about an hour after waking up. He said he had been at Ed's 20 minutes when Cynthia called to say Omaree was unconscious. Mr. Casaus said he drove straight home and that it took him about 5 minutes. He said the detectives, he told the detectives he got there before 3 o'clock p.m. Mr. Casaus said he picked Omaree up off the floor, put him on the bed, and tried to revive him by CPR. Then he said he and Cynthia took Omaree to the bathroom and held him up in the shower under cold water for a minute. Mr. Casaus said he and Cynthia took Omaree back to the bed and he continued with CPR. Mr. Casaus said he told Cynthia to call 911, but she tried first to find someone to take Nevia and little Stevie. She was afraid CYFD would take them otherwise. She did call 911, according to Mr. Casaus, and the ambulance arrived 15 to 20 minutes after Mr. Casaus said he had returned home. When Detective English asked him about the times he gave, that he said he returned home before 3 o'clock, but 911 was not called until 4:30, he acted surprised, stating, "Are you serious? It was that long? Are you serious? I don't even know. I must have lost track of time." Detective English asked Mr. Casaus about the 3 round marks on Omaree's chest. Mr. Casaus said Omaree was running down the hall and ran into him while he was smoking a cigarette. He said Omaree was wearing a jacket when this happened. When Detective English asked if the cigarette burned through Omaree's clothing, Mr. Casaus said he thought Omaree was wearing a low-cut shirt that day. Later in the interview, Mr. Casaus' story changed. He admitted he never left the residence, but instead was in the restroom when the incident happened. Mr. Casaus said he went into the restroom for about 20 minutes right after he woke up. While in the bathroom, he heard Cynthia yelling at Omaree and the kids screaming and yelling. He said he yelled at Cynthia to calm down, that he was trying to focus. When he came out, he saw Omaree lying by the bouncy horse in the back bedroom. He said this was 2 o'clock to 2:30, shortly after he woke up, although he said earlier that he woke up at 12 or 12:30. Mr. Casaus said Cynthia was running around freaking out and that he told her to call the ambulance. She wanted to get the other kids out of the house first. Mr. Casaus said he did CPR and took Omaree to the shower with Cynthia. They took him back to the bedroom, put him on Cynthia's oxygen, and pressed on his chest. Mr. Casaus was asked if he ever told the other children, Nevia and little Stevie, not to say certain things, and he denied doing so. He then admitted to the detectives that he used heroin in the bathroom that day. He told them he used it that morning. Mr. Casaus said when he was in the bathroom, he heard Cynthia screaming at Omaree and Omaree responding. He said he came out of the bathroom once and Omaree was lying on the bed with Cynthia yelling over him. He said he told her to calm down and that he would be back to help her when he finished in the bathroom. He returned to the restroom and heard Cynthia yelling at Omaree again and heard a few more tumbles, as he called them. When he came out, he saw Omaree lying on the floor next to the bouncy horse. The detectives asked Mr. Casaus why he himself didn't call 911. He said he first thought Omaree was kidding around. Then he said he didn't know where any of the phones were at, and he said Cynthia had the phone in her hand. Mr. Casaus admitted he should have stepped up and just called 911. He said he was paranoid and confused. Mr. Casaus was asked again whether he told the other kids to be quiet. This time he admitted he told them not to say anything, that everything would be fine as long as they didn't say anything about what happened in the room with Mom and Omaree. At 8:30 on the morning of December 28, 2013, Detective English arrived at the office of the medical investigator to observe the autopsy of Omaree Varela. It was anticipated that the doctor would find some sort of brain injury, subdural hematoma, for example, since it was reported by the parents that Omaree had fallen on his head. While Omaree did have the laceration on the side of his head, there was no sign of traumatic brain injury. What the doctor did find was a large quantity of blood in the boy's abdominal cavity, which was scooped out with a ladle. 500 milliliters of blood were removed. Later, Dr. Odi Ukpo, who performed the autopsy, said the most significant thing he found was the amount of blood in the abdominal cavity. This was liquid blood, which meant it was fresh and was associated with hemorrhaging at different locations in the abdomen. It was determined that these injuries were due to blunt trauma. Dr. Upco concluded that more than one hit caused the trauma. He also stated that the blood loss was a quarter of the total blood volume for a child like Omaree. It would not cause immediate death. Hours passed between the infliction of the injury and the time Omaree passed. A year later, in January 2015, Omaree's little sister, Nevia, the one who hovered over his head as Officer Edison checked for a pulse, was living with her Aunt Sylvia and began to talk about what happened the day her brother died. Besides these other people I've mentioned, you will also hear the story she has to tell, a story which more seriously implicates Stephen Casaus. Thank you.
Thank you. Mr. Clark.
Good morning, everyone. So as you know, my name's Tom Clark, and myself, Cindy Leos, represent Stephen Casaus. You all know now, you explained yesterday during voir dire, you heard the state's opening statement. This is a truly awful case. Facts are absolutely beyond terrible. We have the death of a 9-year-old boy who you are going to hear unequivocally was kicked to death by his natural mother. Cynthia Varela kicked and beat this little boy to death, and we can't get around that. You're going to see autopsy photographs of a 9-year-old. You're going to see attempts to resuscitate a 9-year-old. You're going to have to look inside the stomach cavity of a 9-year-old that was filled with blood because his mother beat and kicked him to death. And that is a fact that will escape none of us. This boy's dead, and nothing can bring him back. And sometimes a case will capture the public attention because of its gravity and depravity. And this is such a case. From the very beginning, this case received a lot of attention. We talked about this yesterday during voir dire, and very few of you were able to escape the attention it received in the media, in the newspapers. The facts of this case are so terrible that there was this feeling of a need to punish everyone who could have possibly been involved. Now, in an attempt to seek justice for this dead 9-year-old, it's our contention, and we believe the evidence will show clearly, that a very wide net was cast. That this attempt to seek justice for Omaree resulted in initially our client being questioned by the police, and he was allowed to leave. But as fury over the facts of this case began to grow, there was this feeling that everybody involved, how could the dad have possibly not have been involved? And this wide net was cast. And the problem when wide nets are cast is innocent people get caught up in such wide nets. In this need for vengeance, in this need to punish such an awful act, there is this wide net that was cast. And that is the case in this situation. Because we have benefit of modern technology, you're going to see things like the condition the house was in on this day, the way the other children are acting, the way Steve is acting with his other children. And with modern technology comes real-time evidence of what was happening in the home, what is said by who, when. So there's not going to be any dispute about what people are talking about. And you will be the arbiters of the truth, of the facts in this case. You will determine based on the evidence you hear in open court, not what you may have heard previously, not what you may have talked with friends about. But this case will be decided based on what you hear from the witnesses in the witness box, what's presented to you as exhibits, and what you take back to the jury room at the end of what is going to be a very difficult couple of weeks. Each of you told us that you could be fair and impartial, and we believe you. We trust the system, and we believe the system works. It will work if you indeed are fair and impartial. And if you listen closely, not to what the lawyers say, what lawyers say in opening statements isn't evidence. If you'll concentrate on what the witnesses say and what the witnesses tell you, and remove emotion the best you can, then you'll come to the conclusion that we believe is just and fair. Now, the purpose of opening statement, as Judge Whitaker told you, is for us to tell you what we believe the evidence will show. Not to argue our case, but what we believe the evidence will show. And we believe unequivocally the evidence is going to show several things. First of all, that this young boy was murdered by his mother, that she beat and kicked him to death. That Miss Varela Casaus, Steve's wife, is charged with murder and awaiting trial. That Cynthia has admitted her transgressions. She's admitted her awful acts. And you'll see some of that. She's admitted what she did to a news crew, She admitted what she did in an interview. And she has taken responsibility to some degree, at least previously, for these crimes. The state has their person. They've got the person who did this. It's not enough. You'll hear that the injuries that this young boy received were consistent. The medical evidence in this case will tell you that the injuries are consistent with what Cynthia has admitted to. We believe the evidence will show you that Steve Casaus played no role in the death of this boy. We believe the evidence will show that, to the contrary, Stephen Casaus attempted resuscitation, that he's not trained as a doctor or a medic, but he attempted in a crude way to resuscitate the child, to revive the child, including putting him in the shower, chest compressions, placing an oxygen mask or an oxygen on the child's nose that was in the home. And we believe the evidence will show that Steve is the one who directed that 911 be called, and ultimately 911 responded. A key witness in this case is a very young child. Omaree's little sister, Nevia. And you'll get a picture of what Nevia was. You'll see her on the day that Omaree died. You'll see it in the video. You'll see how she was behaving toward her father. And that's not going to be in dispute. You'll also hear that following the murder of her brother, she immediately began telling her therapists, her doctors, the adults around her, that my mom killed Omaree. She kicked him to death. And that wasn't enough. She told this story about how her mother kicked her brother to death over and over and over again for about 12 months. But we believe the evidence will show you that based on the pressure she received from her therapist and her aunt and the other adults in her life, that she slowly began to change her story to include her dad, her stepdad, Steve. And what we believe the evidence will show is, quite frankly, the little girl's story after a year of pressure, of coaxing, of maybe suggestibility, that only then did she implicate her stepfather, Stephen, in the murder of her brother. What the state frighteningly will ask you to form an opinion on is what the therapists will call the child's truth. The child's truth versus the truth. I'm not making this up. You're going to hear the child was in therapy for about 12 months. The therapy regimen involved her just talking and talking and talking with no attempt to ascertain whether or not the things that were coming out of her mouth were the truth or not. And that's where the therapist will talk about the child's truth. We just wanted her to talk. Well, the child's truth and the truth is what you will be asked to distinguish between. You will be asked to determine whether or not the child is accurate. We're talking about a 5-year-old. You're going to be asked to determine whether or not what she's telling you is what happened, or whether it's a concoction based on pressure in her life. This is going to be a lengthy trial. You're going to have to sit and do something that most people aren't called upon to do. You're going to be asked as best as you can to put your emotions aside and sift through the cold, hard facts. You're going to have to sift through the awful images of a dead boy. You're going to have to sift through the emotions that come along with something as awful as this. And if you follow judge's instructions, and if you follow what you've already told us you're able to do, at the end of this awful experience, you will come to but one conclusion. And that conclusion is Stephen Varela is not guilty of the crimes that he's been charged with. Thank you.
Mr. Clark.
Call your first witness.
Staff is reporting.
The state calls Sergeant James Edison. I'm just getting it ready.
Raise your right hand for me. You solemnly swear the testimony you're about to give to this court here this morning will be the truth, the whole truth, nothing but the truth, and nothing but the truth?
Yes, sir, I do.
Please have a seat there. Please step up to that microphone. State your full name for the record, starting both your first and last name, if you would.
Sure. I'm Sergeant Jim Edison with the Albuquerque Police Department. That's J-I-M, and the last name is E-D-I-S-O-N.
Mr. Jensen.
Sergeant Edison, how long have you been with the Albuquerque Police Department?
Sir, I joined the academy in November of 2007.
Okay. And you received training there?
I did.
Okay. What position did you hold on December 27th, 2013?
I was a patrolman, first class in the Northeast Area Command.
Okay. Sergeant Edison, are you familiar with Stephen Casaus?
Yes, sir.
Do you see him here in this room today?
Yes, sir, I do.
Can you point him out and tell us how he's dressed?
May I stand?
You may.
Mr. Casaus is at the defense counsel's table. He's sitting in the middle with a white shirt and dark slacks. He wears his hair very short today.
Okay. Thank you. Could the record reflect a positive identification, Your Honor?
Please.
Thank you. Did you have occasion to come into contact with Mr. Casaus on December 27th, 2013?
Yes, sir, I did.
How did this come about?
There was a dispatch that I overheard about a child that was seriously in. Excuse me?
You're saying, I'm sorry.
Okay.
First of all, stand when you object. Response?
What were you doing at the time?
I was on my way to a police call when I heard on police radio the need for assistance at an address on Comanche for a seriously injured child.
Objection, Your Honor.
Overruled, let's go.
Go ahead, that's fine. And what did you do?
I diverted and advised the dispatcher that I would be en route to that call. I was very close to the location, and I switched to Code 3 operation, which is full lights and siren.
Okay. And again, the location where this incident occurred was?
It's Comanche and San Mateo. It's
Okay.
just west on the north side of the street.
And it was in Albuquerque, New Mexico?
Yes, sir.
Okay. And what was your understanding of the reason for the dispatch?
The reason for the dispatch, you said? I interrupted you. The information provided to me by the dispatcher.
Your Honor, objection. Counsel?
Come forward, counsel. Yes.
And what did you learn the nature of the problem was?
Do you mean how I was originally advised from the dispatcher?
I mean, what did you learn? What was the source of the problem?
The child was unconscious, possibly not breathing.
Okay, very good. And what time did you receive this, hear this dispatch message?
Around 4 o'clock.
Okay. And when did you arrive at the residence?
About 90 seconds later.
Okay. And what did you do?
I parked right at the bottom of the driveway, and I immediately went to the front door in an attempt to make entry. The door was locked. I pounded hard on the door and announced my identity and my presence and the need to open the door. I then began to look for a way to get into the home or the backyard because of the nature of what I had heard the injury was. I was trying to get somewhere into the home under the exigency to make
And how did you
entry.
ultimately get in?
Mr. Casaus opened the door for me.
Okay. Did he say anything when he opened the door?
Something to the effect of come this way or in this way, something to that effect, sir.
And which way did he direct you?
Well, he had poked his head out of the door. I was just to the west of where he was. I saw him go back into the home, and I followed. Mr. Casaus walked through the home and veered towards the east and said that way, and he pointed towards the west.
Okay. And what did you do then?
I went the direction that Mr. Casaus had pointed rather than the way Mr. Casaus had gone. So I walked through the living room and through a kitchen into a large bedroom.
Can you describe that bedroom?
It's very large. I would say, as a reference, it's about the size of a two-car garage. Along the left-hand side is a dresser and a TV, and there's a large bed in the bedroom, basically centered against what would be the far north end of the home and the north end of this wall. And there's either a large window or sliding glass door just to the east in this room.
Okay. Was anyone there in that large bedroom?
Yes, sir.
And who was there?
Cynthia Varela was in the room with two other children.
Okay.
And Omaree.
Okay. And where was Omaree?
Omaree was on the foot of the bed. When you're looking at the bed, he's at the left bottom of the bed. He's laying on his back, his feet up to his knees, and from his knees down are hanging down off the bed. So if you were sitting on the edge of the bed and then you laid back, that would be the position that Omaree was in as a point of reference. And again, I'm looking at the bed and it's to the far left edge of the bed.
And what was Miss Varela Casaus doing?
She was on the phone speaking to someone.
Yes.
She was also speaking to me, and I believe for a time she was using a white bag. At the time I thought it was like a Walmart grocery bag, plastic, full of ice, and she was using that near Omaree's head and neck.
What made you think that that was a bag of ice?
Omaree's neck and head was cold, and kind of humidity cold as well, as if, I mean, you've used an ice bag and you get that feeling of kind of humidity and moisture, and it kind of felt that way. But not deceased cold, just kind of a fresh kind of cold.
And how did Omaree appear to be?
Unconscious, and I began to check for signs of life.
Okay. Did you find any?
I thought I did at first. I had my, they're kind of leather gloves, they're kind of thick, and I remember reaching up to Omaree's, the left side of his, of his neck, and I thought I felt something, but the two children were going on and off the bed, and the bed was kind of moving like kids jump on a bed like a trampoline, and it was moving around a lot. And so it was hard for me to really get a sense of whether I was getting chest rises, if I was feeling a pulse. And so I remember another officer came in, Officer Wright came in. I asked her to remove everybody, and I remember leaning down to kind of feel for breath from Omaree, and that's when I discovered there was no signs of life.
And what did you do then?
It was almost immediately rescue began to enter the room, and I began to assist them to lower Omaree onto the ground so we could start CPR.
Okay. What was Omaree wearing?
Underwear.
Okay. Did you notice any kind of injuries? Or what
Yeah.
appeared to be injuries?
Objection, Your Honor. May we approach?
Sergeant Edison, you indicated you checked him for signs of life. You checked for a pulse. Did you notice anything else about Omaree's person?
Omaree was very thin. Omaree has some mark up near his collarbone and another one near the line of his underwear.
Okay.
Like a small round mark.
Okay. And during all this, what you described as fairly chaotic time, did you see Stephen Casaus?
No, sir. I didn't see him. I saw him momentarily when he opened the door, and then again later after rescue was working on Omaree.
Sergeant Edison, I have here in my hand an item as marked States Exhibit 1. May I approach the witness? Do you recognize this?
Well, I know this to be a CD or a DVR that we would commonly use for our video systems.
Okay. Do you recognize this particular one?
Not from this, sir. Well, let me say this. I saw a video yesterday at the district attorney's office, and it appeared to be this CD. But obviously, I'm just looking at the outside of the CD.
And what is this?
Someone's initials.
Okay. And what did that DVD portray?
Well, I wear a lapel camera built by...
Objection, Foundation.
Well, we're waiting, we're trying to get it, so let's see if we can continue.
I wear a lapel camera designed by Taser, and that goes into an upload system. And when they get released onto DVDs and CDs just like this, sir.
Okay. And the DVD that you observed yesterday, what did that contain?
That was my lapel video, sir. From,
Okay. What was on it?
just as we're speaking to this incident, sir, from my arrival and until it was turned off.
Okay. Was there anything else, from your arrival till it was turned off, and how long was that?
I was on scene for hours, sir.
Okay. And on this particular video, what did you observe yesterday?
I observed my arrival on scene, my entry into the home, my investigation into the signs of life in Omaree, and my conversation with Mr. Casaus.
Okay. Your Honor, the state would move to enter this into evidence as State's Exhibit 1.
No objection, Your Honor.
It'll be admitted.
May I publish it to the jury, Your Honor?
Sure. You need to do it.
I'm going to try to do it.
Do I see it here? Thank you.
I don't know about the volume, just for see. You starting it? I think I can start it from here. Let's see if that works.
Judge, can you manipulate the camera on our table to work as well? It's not a...
Was it not on? You're not seeing anything on your camera?
No, so it's dark.
Great.
That thing was passed, but make it work.
Yeah, you have to turn the monitor on. Right?
There's supposed to be another thing that comes down.
There it is.
There you go.
Yes, sir.
The data CD up there. I think you just scroll up. You have to aim it at the thing. There you go. Okay. You might have to just aim it down.
No volume, so you may have volume control.
There'll be no volume for 30
It comes
seconds.
on a bit later.
There's no volume for 30 seconds.
There's the view, can you see that?
Leave the door open. Where is he? Where is he?
He's right here, sir.
Which one?
Right here. He's right here, sir.
All right.
Yeah, I got him right here. He told me to call you, that's what he told me to do.
Okay, can you back up? Go ahead and back up.
It's not running
Hey,
right.
buddy.
It's not running right.
Hey, buddy.
It's not operating correctly, sir.
Can you take the kids out of here?
Just stop it for a second, Mr. Not sure why it's not.
They're not in sync, Your Honor.
Yeah.
And there's some, appears like some buffer problem.
Yeah. So run it back to the beginning if you would. Maybe that's the way to do it. Sorry, folks, a lot of technology.
Maybe open it and don't start it right away. Give it a moment.
Can you take the kids out of here? Yeah.
It's not in sync.
So let's stop.
He's on his way to check.
You find out what he did? Where you fall from?
Well, let's do this. Maybe we can take a little break, so we just got started, and see if we can make sure we can get our technologists up here and fix this. So let's take a little bit of a break. You've heard a little bit of evidence, but certainly not all that you're going to hear. Just go in and relax. We'll try to get you back here in a few minutes. Please rise for this jury.